The Senator from Nevada.
Thank you, Mr. President. Today, my colleague, Senator Leahy, the chairman of the Judiciary Committee, introduced legislation that would amend the Patriot Act. This new legislation reflects a bicameral and bipartisan compromise that ends the bulk data collection practices currently being used. It also gives our intelligence officials specific rules to follow so that they can keep the operational capabilities necessary to protect the United States from a terrorist attack without compromising the Fourth Amendment of the Constitution. I'd like to thank Senator Leahy for his work, and I'm grateful for his partnership. This important step is necessary for restoring Americans' privacy rights, which was taken by an overreaching federal government in the wake of the 9/11 terrorist attacks. Mr. President, the expanded authority given to the National Security Agency through executive action and the Patriot Act was intended to prevent another attack on America. While I was not a member of Congress on 9/11, I share the horror of all Nevadans watching the murder of thousands of innocent Americans and the profound sadness as buildings in New York City and Washington, D.C. sat smoldering. I understand as well as anyone here the reasoning behind the actions of our nation's leaders that they took to ensure that another attack on America never materialized, and why our leaders felt that no limit should be imposed no matter what the cost. Americans had to be protected against another attack. Viewing the situation from that lens, it's easy to understand how the Fourth Amendment was brushed aside as the United States Senate expanded law enforcement surveillance capabilities with just one dissenting vote. The Federal Bureau of Investigation then used Section 215 of the Patriot Act to expand the scope of surveillance far beyond even what some of the authors believed they were authorizing. The FBI argued that Section 15 provided authority to collect phone data of law-abiding citizens without their knowledge. Specifically, they could use business record provisions to force phone companies to turn over millions of phone calls when there is a reasonable ground or relevance to believe that the information sought is relevant to an authorized investigation of international terrorism. As a result, we now have a bulk collection program in existence where telephone companies hand over millions of records to the NSA as part of a massive pre-collection database. As someone who voted against the Patriot Act time and time again, I believe such data collection practice is a massive intrusion of our privacy, which is why I partnered with the senior senator from Vermont to end these programs. Our legislation tightens the definitions of specific selection term for Section 215 of the Patriot Act and the FISA pen register trap and trace devices so that the information requested is limited specifically in identifying a person or an account or an address or a personal device. With this legislation, bulk collection will be eliminated and the records will stay with the telephone companies. The massive information grabs from the federal government based on geography or email service will no longer be permissible. And the information that is collected, the legislation imposes new restriction on the use and the retention of it. These reforms will help shift the balance of privacy away from the federal government and back to the American people. I am also proud that this bill includes the Frankenheller Surveillance Transparency Act of 2013. I was pleased to join Senator Franken on this legislation because at the very least, the American people deserve to know the number of people whose information is housed by the NSA. For the first time in American history, the government is forced to disclose to the American people roughly how many of them have had their communications collected, Our provisions calls for reports by the Director of National Intelligence detailing the requests for information authorized under the Patriot Act and the FISA Amendment Act. The reports would specify the total number of people whose information has been collected under these programs and how many people living in the United States have had their information collected. They would also permit the intelligence community to report on how many Americans actually had their information looked at by the NSA or any other intelligence agency. Furthermore, these provisions would allow telephone and internet companies to tell consumer-based information regarding FISA court orders they receive and the number of users whose information is turned over. The principles outlined in this bill to increase transparency for Americans and private companies would clear up a tremendous amount of confusion that exists within these programs. And our private companies need the added disclosure. The Information Technology and Innovation Foundation estimates that American cloud computing companies would lose $22 to $25 billion in the next 3 years because of concerns about their involvement with surveillance programs. The analytics firm Forrester put potential losses much higher at $180 billion. I want to be clear. I share the concerns of all Americans that we must protect ourselves against threats to the homeland. I believe that terrorism is very real and that the United States is the target of those looking to undermine the freedoms we hold as the core of our national identity. And if the bulk collection program in existence were bearing so much information to protect the homeland, I would change my opinion on the need for the USA Freedom Act. However, the bulk collection program has simply not provided the tangible results that justify a privacy intrusion of this level. We know this because on October 2nd, 2013, the chairman of the Senate Judiciary Committee, Senator Leahy, asked NSA Director Keith Alexander the following question, and I quote, "At our last hearing, the Deputy Director, Mr. Inglis, stated that there's only really one example of a case where, for the use of Section 215, both phone and records collection, terrorist activity was stopped. Was Mr. Inglis right?" To which Director Alexander responded, "He is right." I believe he said too, Chairman. Mr. President, Congress has authorized the collection of millions of law-abiding citizens' telephone metadata for years, and has only solved 2 ongoing FBI investigations. Of those 2 investigations, the NSA has publicly identified 1. And in fact, that case could have easily been handled by obtaining a warrant and going to that telephone company. It is the case of an individual in San Diego who was convicted of sending $8,500 to Somalia in support of Al-Shabaab, the terrorist organization claiming responsibility for the Kenya Mall attack. The American phone records allowed the NSA to determine that a U.S. phone was used to contact an individual associated with this terrorist organization. I'm appreciative that the NSA was able to apprehend this individual, but it does not provide overwhelming evidence that this program is necessary. Mr. President, the Obama administration has come to the same conclusion. So has the intelligence community. The operational capabilities the intelligence community relies on to conduct their mission to keep us safe will not be impacted by the USA Freedom Act. If it were, the intelligence community and the administration would not have brokered this compromise legislation. Ending the bulk collection program and giving Americans more transparency so they can determine for themselves whether they believe these programs should exist is an obligation we have to all of our constituents. We have a bill introduced today that would give our law enforcement authorities the tools they need to keep us safe, also staying true to the Fourth Amendment. I encourage my colleagues to support these important reforms, and I hope it can quickly be considered by this chamber. Thank you, Mr. President. I yield the floor.